All right. So I think people are still kind of joining, but we'll go ahead and get started because we only have an hour to talk about this important case. So I just want to start by welcoming everyone and thanking the CLA and Venus DeCoy for all of her assistance in setting up this event. My name is Allison Westfall-Kong, and I am the current chair of the Committee on Federal Courts, which is a standing committee of the California Lawyers Association's litigation section. And our committee is just so pleased to host this event in honor of the 75th anniversary of Mendez versus Westminster, which held that the forced segregation of Mexican American students into separate Mexican schools was unconstitutional. This decision is notable because it happened in our own state of California and came down nearly a decade before the landmark case of Brown versus the Board of Education. And despite the significance of the case, not as many people are familiar with it. And I know that, I wasn't taught about it in schools growing up, and I didn't even learn about it in law school. So it wasn't until after law school that I became familiar with the decision. But I'm happy to report that I was talking to my 9-year-old daughter this morning and telling her that I was, going to be part of this panel and telling her about the Mendez case. And she responded that she knew all about it because she learned about it in school. And she actually commented that she thought it was so unfair, especially the fact that the Mendez children were not allowed to enroll in the white school, but their cousins were, in part because their cousins had lighter skin. So I like to hear that it's being taught in elementary schools because I do think that children, have such an innate sense of what is right and what is wrong. And she just immediately saw the injustice in that. So we're lucky to have two very distinguished speakers today, Eddie Jauregui and Cuauhtémoc Ortega, who I'll introduce in a moment. And they actually teach a class at USC Law entitled Los Angeles, Latinos and the Law, where as part of that curriculum, they discuss the Mendez case. So during our discussion today, they will talk about the factual and legal landscape at the time of the Mendez case. They'll talk about the trial and kind of what happened at the district court level, the Ninth Circuit decision, and just the significance and the impact of this case that really laid the groundwork for Brown v. Board and its progeny. So I'll go ahead and introduce the speakers. Eddie Jauregui is a litigation partner at Holland & Knight in Los Angeles and a member of the firm's white-collar defense and investigations team. He served as an assistant United States attorney in the Central District of California from 2014 to 2020. And as a federal prosecutor, he prosecuted complex fraud and corruption cases, including the prosecutions of former LA County Sheriff Lee Baca and Under Sheriff Paul Tanaka, earning him the California Lawyer of the Year award in 2018. Eddie served in the office's major fraud section for several years before being appointed deputy chief in the general crime section, where he supervised new prosecutors. Eddie previously practiced at Jenner & Block in New York and Los Angeles and is a graduate of Columbia Law School, where he was a Harlan Fiske Stone Scholar and recipient of the Valentine Wertheimer and Alan Morrow Prizes. Eddie externed for then Judge Sonia Sotomayor on the Second Circuit and clerked for the Honorable Jan Du Bois of the U.S. District Court for the Eastern District of Pennsylvania. He holds a master's degree in public policy from the Harvard John F. Kennedy School of Government and a bachelor's degree in public policy from Occidental College. So thank you for joining us, Eddie. And our next speaker is Cuauhtémoc Ortega. Cuauhtémoc is the federal public defender of the Central District of California, a position he was appointed to in October 2020 by judges of the Ninth Circuit Court of Appeals. He started in the office of the federal public defender in 2010 as a trial attorney after working at Munger, Tolles & Olson. As a trial attorney, he has handled a number of jury trials on a wide range of offenses, including firearms, fraud, and threats. In 2016, he became a supervisor in the office and chair of the diversity committee of the office and was promoted to chief deputy in 2019. As federal public defender, he supervises over 200 attorneys and staff members across 3 offices. He's also a graduate of Columbia Law School, where he was executive articles editor of the Columbia Law Review and recipient of the Archie O. Dawson Prize for Oral Advocacy. He clerked for the late Honorable Alice Marie Stotler, U.S. District Judge for the Central District of California. He received his bachelor's degree in political science from UCLA, where he was editor-in-chief of the Daily Bruin student newspaper, and he currently sits on the executive committee of the CLA's criminal law section and the judicial appointments committee of the Los Angeles County Bar Association. So thank you so much, Cuauhtémoc and Eddie. And just to get started, Eddie, perhaps you can set the stage for us and just describe how schools came to be segregated for Mexican-American students in Southern California.
Sure, thanks very much, Allison. And thank you to the CLA for hosting this webinar. It's our pleasure and honor to speak on the Mendez case, which, as Allison pointed out, is a very important case in the history, not just of Mexican Americans and Latinos in California, but for all people of color and civil rights, students of civil rights in the United States. Allison, to answer your question, our case begins in 1943 in Southern California. And as you noted, at that time, Mexican American students were segregated into Mexican schools, separate Mexican schools. I think Cuauhtémoc will go over some of this, but the state of the law at the time was that California law authorized the segregation of Native Americans and persons of Asian origin. Mexican Americans were not expressly addressed, or Latinos were not expressly addressed in the law at the time. But as the population of Mexican Americans grew very rapidly in the first part of the 20th century, it became a practice of many, many school districts throughout the state to put Mexicans in separate schools. The Los Angeles public schools, the Orange County public schools had distinct separate schools that were very, very inferior to the white schools. We'll show some pictures in a minute of what what Mexican school looked like in the Mendez case. But needless to say, the goal of these schools was essentially to train Mexican students for jobs that educators believed suited their essentially their biology, right? Because at the time there was a very big trend in essentially pseudoscience that said that Mexican persons and other people of color were inferior to whites biologically and otherwise. And the schools essentially taught girls to become maids and boys to become blue collar workers. And in Orange County at the time, I think there were at least 15 Mexican schools. If you were deemed to be Mexican, and we'll get to your example in a second that you mentioned about the cousins, you were put into a Mexican school. There were examples of people of Latino descent or Mexican descent that were included in white schools. Often that was because either the number was so low that the school districts didn't bother to segregate them, or because they were deemed or considered to be quote unquote Spanish. In the example that you raised, well, I'm getting ahead of myself. So that is the answer to your question, Allison.
Thank you so much, Eddie. And Cuauhtémoc, perhaps you can talk about kind of the legal landscape at the time and the state of the law on segregation before the Mendez case was filed.
Sure. I'll talk about it in terms of California law and also in terms of national and federal law. In California, as Eddie said, there was statutory implementation of segregated education, but it was limited specifically to 3 categories. Children of people who were, quote, from Chinese, Japanese, or Mongolian parentage, end quote, were allowed to be segregated into separate schools, and everyone else went to other schools. So that statute predates some of the Supreme Court case law that we'll talk about. And there's actually a California Supreme Court case that predates Plessy versus Ferguson, which was kind of a precursor to some of the concepts that were established there, that said that separate but equal facilities were okay. So in California, separate but equal existed well before Plessy versus Ferguson became law in 1896. So Plessy versus Ferguson wasn't an education case. It was a case that involved railroad passengers. And in that case, the Supreme Court ruled that the 14th Amendment requires that people be treated equally, but it doesn't require that they be treated equally in the same spaces. So as long as you treated people equally, you could implement state laws and state policies that separated people and kept them segregated. Cases that came after Plessy, but before Mendez, did veer into the education realm. So notably, for example, in 1908, there's a case called Berea College versus Kentucky, which explicitly upheld the power of the states to mandate that white students and Black students be educated separately. There was another Supreme Court case in 1927 called Gong Lum versus Rice, which was brought by a Chinese descent student who was not allowed to go into a white school. The person was sent to the school for African Americans, and the court ruled that he was not deprived of equal protection by being sent to a segregated school, even though it was segregated with the intention of segregating a different race. So that was in 1927. So by the time that Mendez is filed in 1945, Plessy versus Ferguson's separate but equal doctrine has been expanded to other areas, including schools. And so the legal landscape at the time that the case is filed is that separate but equal is the law of the land. And we'll discuss this a little later, but it informs a lot about how the case is brought and what the litigation strategy is by the plaintiffs, because going into court, Plessy versus Ferguson is still good law. It wouldn't be until 10 years after Mendez is filed that Brown v. Board comes down and overrules Plessy versus Ferguson in the cases that applied its holding in the education arena.
Thank you. And Eddie, I know you were about to get to this in your previous question, but do you want to now tell us kind of the factual background leading up more directly to the Mendez case and what kind of led them to file this lawsuit?
I do, and I'm going to share my screen so I can share some images with our audience as well. Can you guys see my screen?
Yes.
Okay, so this absolutely fascinating case starts, as I said, in 1943. Before I get into what happened when the Mendez parents sought to have their daughter Sylvia enrolled at the white school in Westminster, I'm going to give you a little bit of background. So these are Sylvia Mendez's parents, Felicitas Mendez and Gonzalo Mendez. Felicitas Mendez was of Puerto Rican background. So I say that because often this case is framed as a Mexican-American case. The judge discusses it and the Ninth Circuit opinion discusses it as a Mexican-American case. But it is important that Felicitas is of Puerto Rican background, I think, for two reasons. Number one, she was an American citizen, right? And she had a firm understanding of her rights as an American citizen. Gonzalo also was an American citizen at the time of the suit, but he had only become an American citizen, I think, 5 years prior to that. The second is because I think this case is as I mentioned earlier, it is an important Mexican-American case, but I think it's a case that all of us should be aware of, and many of us can take pride in for what the parents did. And also, Felicitas was a very powerful player in this story, so I wanted to highlight her a little bit. Felicitas and Gonzalo lived in Orange County, California. And at the time, they owned a couple of cafes. Gonzalo had a background as a farmer. He had experience in farming, but like I said, they owned some cafes in Orange County, and they were better off than other Mexican-American families. They had a banker who handled their finances, and the banker one day said to Gonzalo, I know you've always dreamed of being a farmer. I need to talk to you about a family called the Minomitsu family that is in a Japanese internment camp. They also worked with this banker, and the banker said to Gonzalo that the Minomitsu family wants someone essentially to take care of their property while they're in an internment camp. And would you like to be that person? And Gonzalo said yes. And Gonzalo and a then very young Sylvia Mendez actually traveled to Arizona to meet with the Minomitsu family and sign the lease so that he would essentially become the caretaker of the farm. I know it's very hard for people to imagine, but Orange County and much of Southern California at the time had a lot of farmland, and the Minomitsus had an asparagus farm, and they also grew chili peppers, avocados, citrus, etc. So the Mendez family took over the farm, and Gonzalo Mendez was making pretty good money doing so. He moved his family from one part of Orange County to another part of Orange County and wanted to put his daughter Sylvia in the school that he went to, which was the Westminster Main School. I think there's another name for it, but for our purposes today, we'll call it the Main School. I know in her public comments, Sylvia Mendez often calls it the Main School or the White School. Gonzalo was able to go there because I think what other people would say, at the time that he was in elementary school, the Mexican population in Orange County was much smaller. And so maybe they just weren't as threatening, and there hadn't yet been a need to segregate, to create a whole bunch of Mexican schools to handle the huge influx of Mexican immigrants to California after the Mexican Revolution in the 1910s. What happened was he asked his sister-in-law to take his kids to enroll them in the Westminster Main School. The sister goes with her own children, the Vidari children, Viduarri, they had a French name, and the Mendez children to enroll them. And the school administrators at the school declined, for lack of a better term, to enroll the Mendez kids. And what they told the sister-in-law was, we can take your children because they are Vidaris, but we can't take the Mendez children because they are Mendezes, and Mexicans have to go to a Mexican school. So the sister came back, I want to say her name was Soledad, came back and talked to Gonzalo about what happened at the school. And needless to say, everyone was extremely upset about it, but the school refused to let the Mendezes in. Over the course of the next year and a half or so, the Mendezes tried unsuccessfully to get their children into the main school. They decided that they would get a lawyer to represent them. And what they did was they found a lawyer named David Marcus, who was ultimately from Pasadena, who had taken on the city of San Bernardino in a Mexican-American discrimination case. At the time, the city of San Bernardino had refused to allow Mexicans to use the public pool except for on quote unquote Mexican Day. What they would do is essentially let whites use the pool 6 days out of the week. And on the 7th day, before it was cleaned again for reopening to whites, they would allow Mexicans to use it. David Marcus had sued successfully the city of San Bernardino to put an end to that practice, and Gonzalo got in touch with him. Marcus was a Jewish American who was married to a Mexican woman, and he had his 2 Mexican American daughters. I say that because I think it's relevant to the case and important to the cases we'll see as we go on. And Marcus agreed to take on the case, but he told Gonzalo that if you really want to do this, you should have others join you. We should find out if this is the practice elsewhere. Long story short, they ultimately ended up getting families, 5 families, the Mendezes and 4 other families together. And on behalf of a class of 5,000, the 5 families led by the Mendezes sued the school districts of Westminster, Garden Grove, El Medina, and Santa Ana. The Mendezes sought help from some Mexican American and other organizations. They weren't able to get financial help for it, but because Gonzalo was doing well in his role as caretaker of the Minimitsu farm, they were able to, by and large, finance the litigation themselves. Interestingly, today, still, or at least I should say in recent years, we've seen comments from both Sylvia Mendez and some of the Minimitsu daughters about how they have stayed in touch and how incredible this sort of part of the story is, because the injustice against one community is essentially what allowed the Mendezes to fight the injustices against another community. Just such a fascinating aspect to the case. But that is how the case started, Allison. Long story, long answer to your question.
Great. Well, very, very interesting. So thank you, Eddie. And now, Cuauhtémoc, could you just tell us what claims did the Mendezes bring, and were there any claims that they didn't bring that might surprise people?
Sure. So as Eddie was saying, when the lawyer agreed to take on the case, they thought about how to present this petition strategically, and specifically, they wanted to figure out a way to get it into federal court. Philippa Strum, in her book about this case, talks about the lawyer wanting to do that because he could foresee the potential impact this case could have, not just in Orange County, but in other states and in the country nationwide. So the petition that's filed with the district court to start the case alleges Fourth Amendment equal protection claim. It asks for declaratory and injunctive relief under the 14th Amendment Equal Protection Clause. And though not explicitly placed in the petition that starts the case, there's also a state claim that is raised throughout the course of the proceedings. And then later on, as we'll discuss later, is the basis on which the Ninth Circuit affirms the district court's ruling. So speaking broadly, there's 2 claims. The first claim is that the way that the school districts are excluding persons of Mexican and Latin descent specifically is in violation of the Equal Protection Clause of the 14th Amendment. There's a very deliberate decision to not make the case about race because, as we were discussing earlier, there's controlling Supreme Court law that allows segregation based on race. Plessy versus Ferguson is still the law of the land. So the lawyers figured if we go into federal court and say these students are being segregated based on race, the court would dismiss it, saying, well, there's a Supreme Court case that says that's okay. So they structured the petition not on race, but on descent and origin. And specifically, as the petition says, and I'm reading the petition right now, persons of Mexican and Latin descent, which allowed the lawyers to bring the equal protection claim without it being foreclosed automatically by Plessy versus Ferguson. And the other subsidiary claim was based on state law. And the thrust of that claim was California permits segregation only in a limited set of circumstances. It permits segregation for persons who are of Japanese, Chinese, Mongolian, or as the statute phrases them, original Indians. The state allows segregation of those categories of people. Persons of Mexican and Latin descent are not included in the statutory language as persons that can be segregated. So it's a violation of California statutory law that the school districts are implementing these practices. So that was the state law claim, and both are presented, I think, as any practicing lawyer even today would attest to. When you're filing an original complaint to start a case, you want to put in as many claims as you think might benefit your client. And so even though the lawyers in this case were hoping not just to get relief for their clients, but to have a broader impact outside of their district, they included the state law claim so that there was another claim on which their clients could obtain relief.
Great, thank you. So turning it back to Eddie. So now the lawsuit is filed. Can you tell us what happens in the trial court and what happens in the trial? Because there is a trial in this case.
Sure, of course. I'm going to share my screen again. And actually, if you don't mind, Allison, I'm just going to take a step back.
Sure.
Well, first, for everybody else, for everybody's sake, this is an image of Sylvia Mendez, and we'll see another image of her in this compendium of photos that I put together. And this is an image of the Mexican school where children of Mexican descent went. And in hearing Sylvia Mendez speak, she'll talk about how dilapidated and run down this school was and how it didn't have a playground. It essentially was surrounded by dirt, and that it had a fence that separated it from the other school, and that fence was electrified. And so if a child touched it, it was meant to keep cows out. I know it's very hard for people to imagine, but we are talking about farm country still in some respects. And so if a child got close to it, it was potentially dangerous. And then I've obviously already shown a picture of the white school. Before I get to what happened at trial, because I think this is so important, I wanted to step back and talk about what some of the parents said about what was happening and why this was so important to them. The thing that comes across to me most sort of impactfully when I prepared to teach the Mendez case and when I was learning about the Mendez case was the depth of the pain, shame, and embarrassment that the parents felt on behalf of their children, and I'm sure that the children themselves felt in the way they were being treated at the time. Okay, as I mentioned, there was a trend in some aspects of scientific literature about the biological capabilities of people of color. I think probably many of the people on this Zoom are familiar with that, but it had real life consequences for the kids because they were very clearly seen by all of the leaders of the school districts at issue in this case as being the thing that came across the most is that they were unsanitary. So the main claim that the school districts offered for why they had to separate the kids is because of language, right? It was that, well, the kids, these are Mexican kids, they don't speak English well enough, and so we have to put them in separate schools for their own benefit. But when push came to shove, and when the parents started to push back, it became obvious that another reason, and probably the real reason, is because the superintendents and other officials saw Mexicans as unclean and unsanitary and as foreign and not able really to keep up with white children. And Cuauhtémoc mentioned a book by Philippa Sturm. She quotes some of the parents, and you know, as I mentioned, their sort of anguish comes across very clearly in this. And what some of the parents say to the school superintendents is how embarrassed they are about the way their kids are being treated. And that even the Filipinos and Japanese who are present in Orange County at the time and are actually allowed to attend the white school, even though California did permit the legal segregation of Asian persons of Asian origin, that even the Japanese and the newly arrived Japanese would make fun of and laugh at Mexicans because of the way they were being treated in the school. And that essentially what the schools were doing was conveying a message to everyone else that Mexican children were less than. And they also gave reports of, teachers and school administrators ordering all Mexicans to report to the nurse's office to be checked for lice, to be checked for tuberculosis and other sort of illnesses, because a lot of the school children did work on the farm. And so there was some aspect of like hygiene that was relevant, at the time. But what came across instead was, you guys are all dirty. And so we have to treat you differently, and you can't keep up with white children, and you shouldn't be with white children. And that's going to come across in some of the testimony. Okay, so fast forward to trial. So David Marcus is representing the plaintiffs. If you look at the case, what you'll see is that there is amicus. There are amici who are involved at the district court level, which is something that I wasn't really familiar with. And one of the attorneys who was involved at the time was an attorney who had already represented Mexican youths in a case called People versus Zamora. And if anybody is familiar with the the story of the Zoot Suitors in LA, A.L. Weirin was one of the attorneys who represented the boys in the case called People versus Zamora, which predated the Zoot Suit riot. The arguments, Cuauhtémoc has already laid them out, what the arguments were on both sides. And Marcus immediately attacks the school district's reasons for segregating Mexican children as pretext. And his aim at trial is to show that they didn't actually do anything to determine whether the children of Mexican descent needed separate bilingual education or separate instruction in Spanish, that all they did was say, do you have a Spanish last name? If so, you're going to the Mexican school, or something like that. Marcus was aided tremendously at trial by the fact that many of these individuals, or one in particular, the school superintendent for Garden Grove, had written a master's thesis when he was a master's student, I believe at USC, discussing all of the ways that Mexican people were inferior to whites. And Marcus, of course, knew this going into the trial. So if I may, I'll just read to you very quickly a couple of lines from Marcus's master's thesis, which starts, Southern California is faced with a predominance of two races of people in its schools. Mexicans were an alien race that should be segregated socially. And then Philippa Sturm notes that this had been accomplished in Southern California, quote, by designating certain sections where they might live and restricting those sections to them. Upon investigation of the mental ability and moral characteristics of the average Mexican school child, it is evident that this segregation is a condition which is advantageous, to both the white and the Mexican child. Segregation into separate Mexican schools seems to be the ideal situation for both parties concerned. He then goes on to say that Mexicans suffered from a number of health problems, including malnutrition, due to the type of food that they eat, including quote unquote greasy mixtures of food, and a number of communicable diseases. He talks about how people of the Mexican race are of a less sturdy stock than the white race. And then he goes on to list all of their personal hygiene problems, which leads to a number of ailments and conditions that plague the Mexican American population. So this is the school superintendent of the District of Westminster. And so David Marcus going into trial already knows this, okay? And his goal is basically to show Kent, the Westminster superintendent, for what he is. Cuauhtémoc noted that part of the trial going into, part of the strategy going into this, I'm sorry, I I'm confusing myself here. Marcus puts Fisher on the stand. I'm sorry, yes, Cuauhtémoc mentioned the whole thing about whether or not this was a race case. Marcus is very clear with the court that this is not a race case. Of course, Plessy would have foreclosed it if it was a race case. But what's interesting and what comes out at trial multiple times is that Marcus on a few occasions slips, the defense on a few occasions slips, and one of the school superintendents at some point does actually refer to people, Mexican people, as people of a different race. There's a break. The witness confers with his counsel, comes back to the stand and says, I got it wrong. Mexicans are not, of course, Mexicans are not of a different race. They're of the same race as whites. What's so interesting about this is that although as a matter of sort of federal government policy, Mexicans were considered white unless they obviously were not, right? Unless they obviously were not. It wasn't because the government writ large necessarily viewed Mexican people as white. In fact, over a decade earlier, the US government did try to sort of change the census categories to include something like a Mexican race. And what happened was that the government of Mexico, according to Philippa Sturm, pushed back on it. And so they withdrew from that. And so by the time this case comes up as a matter of sort of census policy, Mexican people were still seen as white. And by the way, sort of this does continue for a very long time, so that even people of my vintage, unless you are obviously not white, your birth certificate may say that you are white. So, so that was sort of an interesting aspect of what happened at trial. Marcus puts Kent on the stand, and Kent sort of can't help himself, right? So he gets Kent to admit that he views Mexican people as being biologically inferior and inferior to whites in many, many ways. And then he gets him to sort of list all the ways that they are. So if I can just get my notes, I'll tell you what he says about that. He says that Mexican students are lower intellectually than Anglo students, and that they would naturally have a feeling of inferiority if they were put together with whites, because they are of an inferior economic standing and they wouldn't be able to compete with the quote unquote American way of living. He also talks about them having less of an ability to work or a desire to work, that they are inferior in moral ways and in hygienic ways, and in social ways, and that it's necessary basically to segregate Mexican children from white children, not just for the benefit of white children, i.e. to protect them from all of, the sort of the ghastly ways that Mexican kids are terrible, but because it will make the Mexican students feel bad if they have to compete with people who are better than them. At some point, Judge McCormick says to Orange County Council, who's representing the school districts, if your concern is that the Mexican students shouldn't be mixed with white students because of language capability, why don't you just allow them to go to the same school, put them in separate classrooms, but allow them to integrate and play together at playtime and at other times? And Superintendent Kent helpfully explains to Judge McCormick that, well, Your Honor, you have to understand that Mexicans are just different, and naturally they would segregate themselves from the white students. And also I'm paraphrasing here, but essentially, like, they are superior in some ways, and that is that they grow faster than white children, and so they're not going to really be able to socialize together either. So he gets all of this testimony out of Kent frankly quite easily. The other thing that ends up happening, which is pretty remarkable, is that another one of the superintendents, I believe the Westminster superintendent, if I can just find my place in my book, gets up and says, Your Honor, the children, the Mexican children, they won't be able to, we can't really mix them. Here it is. We can't really mix them because the Mexican children haven't been brought up in the American culture. And it would be problematic to mix them at this point. And the judge, David Marcus, says to Harris, the Westminster superintendent, what distinction did you find amongst these children in their cultural development, whether they speak the English language or they don't speak the English language? And the superintendent says, in an English-speaking home, English language, there are certain cultural backgrounds which undoubtedly were formed, many of them, and it came in earlier days from England. Out of those come Mother Goose rhymes. Out of those come stories. Out of those come stories of our American heroes, stories of our American frontier, rhymes, rhythms. Now let us compare the cultural background which the child of Mexican-speaking families comes to us with. He apparently has not had those stories read to him in the English language. He has no conception of them. And the fact of the matter is that as to certain objects, he doesn't know their meaning in English. He knows them in Spanish. He has no conception of them when you put them in English. I read that to you because I was just struck that essentially the testimony is we have to separate these kids because they don't know Mother Goose. Never mind also that California had only been a state in the United States for less than 100 years, and that the traditions that were present in Southern California in the Mexican American community had, of course, been there since before California was a state in the United States, and when all of California was part of the Republic of Mexico, and before that part of Spain. Mexican Americans have been in California since the Spanish came to Alta California. So it was just sort of remarkable and shocking to hear some of this testimony. But the sort of most important thing, Allison, and then I'll wrap up here, that Marcus did is that he brought expert witnesses to testify from Stanford. They were Stanford and UCLA trained experts. And the reason that was important and the reason Marcus was so smart to do that is that because what was obviously a problem for the judge, and he says this to some extent, he says, the problem I have here is that to me, there is a very harmful effect in segregating students, and it's harmful to the white students, it's harmful to the Mexican students, and it's harmful to our democracy. They have to mix. They have to mix if we're going to have a quote unquote common American culture. And he put the defense side on notice that he was concerned about that. And what Marcus did is he calls these experts to the stand to testify, and they go on to testify that it is extremely harmful and hurtful to the Mexican students to be given a message by the schools that they are inferior, and that it is going to make them antagonistic towards the white race. And it is also conveying the wrong message to the white students that they are superior to the Mexican students. And the judge loves the testimony and ultimately goes on to rule, which Cuauhtémoc is going to discuss, but that testimony was very important to him.
Great, thank you. That's also interesting and a lot of unbelievable facts there, Eddie. So Cuauhtémoc, could you please tell us about what the trial court's decision was? And just because we're starting to run short on time, I'll also pose the question about what kind of is the case appealed, and do the arguments kind of change on appeal, and are we seeing more amicus briefs?
Sure. So Judge McCormick decides the issue both on state statutory grounds, as we were discussing earlier, and then he goes on to also rule based on the equal protection claim. And so with respect to the state statutory issue, he basically concludes that the segregation practices are, quote, irreconcilable with the California statutory scheme. because California, as we've said, only specifies certain types of permissible segregation. But one interesting thing is that he goes further and says that other provisions of the Educational Code of California specifically allow for the children of Mexican parents, even if they're not citizens, to attend public schools in California. So the legislature was aware that because the state is right next door to Mexico, that there's going to be non-citizen parents with kids here in Southern California who want to enroll them in school. And the law did not say that those kids cannot go to the school. So the judge says that the practices just cannot be reconciled with the statutory scheme, which allows the children of even non-citizen Mexican parents to attend the school, and did not include those students in the categories of people who it said could be segregated. But the interesting thing and the most powerful thing about the opinion is that even though he could have stopped there, he goes much further and basically, addresses Plessy versus Ferguson head on. And some commentators have thought about why he did this, and a couple of the commentators that are cited in some of the materials speculate that Judge McCormick had a reputation for being what some people refer to as a moralist. He viewed his job as a judge, as a very important job, but also he thought of himself as wanting to do the right thing, and to take positions that were consistent with his moral values. So, for example, he struggled a lot with cases involving the death penalty because of his Catholic faith. And he was a big proponent of prohibition, I learned, and sat on commissions that advocated for prohibition in the earlier part of the 20th century. So he goes on and says, and I'm going to read the part of his opinion that I think squarely takes a shot at Plessy versus Ferguson. Quote, "The equal protection of the laws pertaining to the public school system in California is not provided by furnishing in separate schools the same technical facilities, textbooks, and courses of instruction to children of Mexican ancestry that are available to the other public school children, regardless of their ancestry. A paramount requisite in the American system of public education is social equality. It must be open to all children by unified school association, regardless of lineage." And as Eddie was discussing earlier, the judge was really moved by the expert testimony that was put on by the plaintiffs, and he cited it in rebutting the defense claims that the separate treatment the Mexican lineage students received was due to language. I'm just going to read briefly another very powerful, I thought, section of his opinion that touches upon and is based on the expert testimony, when he says that the evidence clearly shows that Spanish-speaking children are retarded in learning English by lack of exposure to its use because of segregation, and that commingling of the entire student body instills and develops a common cultural attitude among school children, which is imperative for the perpetuation of American institutions and ideals. It is also established by the record that the methods of segregation prevalent in the defendant school districts foster antagonisms into children and suggest inferiority among them where none exists. So, I think that if we had more time, we'd get a little more into like the value of these expert witnesses to, I think, pushing the judge to go beyond just making a limited statutory decision and really going for it and granting the declaratory and injunctive relief also on equal protection grounds. But just to kind of keep it moving, since I know we're short on time, the case was appealed by the defendants, and the same lawyers who handled the proceedings in district court handled the appeal. But the difference, and Eddie's going to talk about the substance of the appeal, but the difference between the district court and the Court of Appeals is that in between the two, you had the case develop a lot of significant national attention. And so a lot of social justice organizations joined in as amici and filed their own briefs in support of the Mendez plaintiff appellees. And notably, like one of the amici were the NAACP lawyers, which later bring the Brown versus Board of Education case. And when they're asked about it later on in retrospect, they acknowledged Mendez as, I think one of them referred to it sort of as an area to kind of explore how an attack on Plessy versus Ferguson might look in this kind of context, and kind of audition the arguments before considering whether to bring them explicitly as race-based claims in federal court in a separate case. So it definitely had an impact immediately and before the Court of Appeals made its decision, but I'll pass it along to Eddie to discuss the Court of Appeals decision.
I'll try to make it quick because I know we actually have a bunch of excellent questions. I want to try to knock some of those out before we conclude. But essentially what happens is the case goes up on appeal. Marcus says to the Ninth Circuit, this is not a race case. We're not bringing up the race issue. Plessy should not foreclose us. Some of the amici disagree, and the Ninth Circuit points that out, that some of the amici say this is a race case and you should overturn Plessy, and here is your opportunity to do it. The Ninth Circuit says, nope, this is not a race case. All parties agree this is not a race case. And so what the court goes on to do is to say, we're aware of those other cases that say that you can segregate races as long as the facilities are equal. Number one, those don't apply because this is not a race case. But number two, in all of those cases, that separation was done by legislative decree and not by executive or administrative fiat, and that's what we have here. So just pointing that out, the circuit says. Then it goes on to say that California allows for the segregation of quote unquote Mongolian, Japanese, and Chinese and Indian children, but it doesn't say anything about Mexican children. And essentially, because it doesn't say anything about the segregation of Mexican children, we essentially conclude that this separation that the school districts are doing is a violation of those Mexican students' civil rights under the United States Constitution. And so it holds that the school districts did violate the students' 14th Amendment rights, but it ties that ruling to the fact that California law doesn't permit it. And so therefore you can't separate them out. What's so fascinating about the decision, though, is that one of the judges writes a separate concurrence. And what he says in that separate concurrence is, look at everything that's happening around the world now. We just got out of the Second World War. What the school districts are trying to do here is segregate essentially one of the groups of the white race. If we were to allow this to happen, what is to say that they wouldn't next segregate Jews? What is to say that they next wouldn't segregate Armenians, Palestinians? And he goes on and on, Dalmatians, Greeks. He goes on and on to name all of the various sort of groups that, had this been permitted, the school districts would not otherwise be able to separate them. And then he goes on to say that he thinks that the school officials should be basically looked at to see whether they had committed a criminal act in so doing. And the judge, the concurring judge, then writes a letter to the governor of California, who, by the way, was Governor Earl Warren, who then goes on to write the decision in Brown versus Board of Education when he's on the Supreme Court, and says, I think this is it, Governor. This is the end of Mexican-American segregation. You got to put a stop to it. And what ends up happening shortly after this case was decided in 1947 is that California undoes all of the laws that are on the books. So the case puts an end to Mexican-American school desegregation, and then California very quickly puts an end to segregation of the other races as well. There's a question about, well, what impact does the case ultimately have? As Cuauhtémoc noted, Robert Carter, who was one of the two NAACP LDF lawyers. By the way, on behalf of the Mendezes entered as amici, the NAACP Legal Defense Fund, the American Jewish Congress, the ACLU, the National Japanese American Citizens League, and a couple of other entities as amici. Representing the NAACP Legal Defense Fund were Thurgood Marshall and Robert Carter. Obviously, Thurgood Marshall went on to be a Supreme Court Justice and Associate Justice, and Robert Carter went on to be a judge in the Southern District of New York, federal judge in the Southern District of New York. When interviewed, Robert Carter said that the brief that they submitted in Mendez was the model for the brief that they ended up writing in Brown versus Board of Education. So that is the tie to Brown that we had mentioned earlier. I'll stop there, Allison.
We clearly need like another hour to really talk about everything, but we are at the 3-minute mark. So we have a lot of excellent questions in the chat. So the panelists, feel free to jump in, but two I wanted to highlight. One person asked, you referenced some reading materials. And so if you could kind of spell those out for just additional resources if people want to learn more. And then another person asked, what lessons or tools can we learn from Mendez as we kind of confront, attacks on the public schools and on libraries today? So I'll leave both of those to the panelists, or just any kind of final thoughts before we wrap up.
Yes, so I think can you guys see this image that I'm putting up of Sylvia Mendez with President Obama? Let me just say, Sylvia Mendez was awarded the Presidential Medal of Freedom by President Obama in 2011, I want to say. Now there are actually a number of books that are written about the Mendez case. The one Cuauhtémoc mentioned earlier was this really great book called Mendez versus Westminster, School Desegregation and Mexican-American Rights by Philippa Sturm. Can you guys see? It's kind of hard to see.
It kind of blurs out when I think because of your background, Eddie.
What's here is an image of a stamp from the US Postal Service that did a commemorative stamp on Mendez versus Westminster. So that's one book. There is an Emmy Award-winning documentary called, I believe it's called For All the Children, and it's free on YouTube. There's also, I wrote an article with one of my colleagues in the Federal Bar Association's Federal Lawyer magazine, and it will have some further citations if you're interested. Somebody else had a great question about that they seem to recall that some of the Mexican students were outperforming white students at the schools in Orange County. Is my memory correct? The response to that is, while some of the Mexican students were testing at very high levels and doing very, very well, the school district said, well, we should keep those students with the other Mexican students, because they will serve as role models for the other Mexican students. So even those students, let's keep them segregated because they can help the other Mexican students. And other questions, let's see. Talked about reading materials. Somebody asked, how are they defining Latin descent? I don't think that's ever decided, but what's curious is that the concurrence in the Ninth Circuit decision does then go on to say, if you can do this to Mexicans, what's to stop you from doing it to Italians, Portuguese, and Spanish, because they are all of Latin, quote unquote, Latin descent.
And I'll just add to wrap up the question about the lessons learned. I think that oftentimes when we think about like this concept about the laboratories of democracy, we think about legislative action in the states and how that percolates up to a national level. But I think Mendez is a great example of how addressing issues at the local level can sometimes create broader attention and change at a national level, even if it takes a longer time. So I find this story very inspiring for that reason, because it started as a county effort here, even though there was a hope that it would have national repercussions. And so whatever the issue that you care about is, litigated in your own court, in your own jurisdiction, and it may have ripple effects that causes change at higher levels of the court and across the nation.
Somebody wrote in that Philibuster's book is available on Amazon. That is correct. That's where I got it. And one of the members of the Minamitsu family published a book last September, The Kindness of Color, which is also available on Amazon. There's also another children's book called Separate is Never Equal that I believe also addresses this case. Wonderful learning opportunities for children. But as Allison mentioned, we're teaching this class in law school, and it is amazing that so many of us had never heard of this case in law school. We had a student who was from El Medina and was blown away to know that this happened in the very place where she and her family had lived. It is a fascinating case, and I urge everyone, if you're interested, to dig deeper.
Well, thank you so much, Eddie and Cuauhtémoc. That was so excellent. You are both so impressive and just a wealth of information on this topic. And I think we all just wish we could hear you for another hour. So thank you again. And thank you to Venus and the CLA. And I hope everyone enjoyed the webinar. Thank you so much.